So good afternoon, everyone, and very good morning to Professor Bačić. Welcome to the session on rule of law and constitutional review. Today we have with us Professor Dr. Petar Bačić. Professor Bačić is a full professor of constitutional law at the Faculty of Law, University of Split in Croatia. He's a member of the Southeast European Law Schools Network Management Board and member of the Croatian Association for Constitutional Law. Sir is the editorial board member of the SEE Law Journal. Professor Bačić is also acting vice dean for international cooperation at the Faculty of Law in Split. He was a member of the President of the Republic's Expert Commission on Constitutional Issues. Besides constitutional law, Professor Bačić also teaches European law, human rights law, as well as constitutionalism and judicial activism. He has written extensively on Croatian and comparative constitutional law and human rights, including several books and 40 scientific articles. Sir, on behalf of the Institute of Law, I welcome you and invite you to address this virtual gathering.
Thank you very much. Good morning and warm greetings to all of you. Namaste. It's such a pleasure indeed to be with you today, but also it's such a pleasure and honor to take part in the International Teaching Month of the Nirma University Institute of Law again. Now, first of all, let me just say that thank you to your colleagues, Professor Shreya Srivastava. Thank you to Professor Sukrit Garg for this kind introduction. Of course, I would like to thank to your Honorable Dean and Director of the Institute of Law, Nirma University, Dr. Madhuri Parikh. And my special thanks should also go to Professor Stephen Barnes. I'm sure that he is very known to you, as Professor Barnes is a great colleague and a precious friend who connected us basically. So that's how Professor Madhuri Parikh then in the end asked me and invited me generously to deliver these lectures. So thank you very much. I appreciate it. And I know that tremendous efforts lie behind all of this International Teaching Month event, and it's a great event basically because connecting all of us wasn't easy as we all live in different parts of the world. I'm currently in my hometown. My hometown is called Split. It's a beautiful town on the Mediterranean, more precisely on the coast of the Adriatic Sea. Maybe some of you have heard for Split. Split is the largest city of Dalmatia. Dalmatia is a region of coastal region of the Republic of Croatia. Republic of Croatia is my homeland. But when I say largest city, you must know that in comparison with India, it's all of course very small. India has roughly 1.5 billion inhabitants, while whole Croatia has less than 4 million. My city, Split, has around 180,000 inhabitants, while Ahmedabad, please feel free to laugh if I'm not pronouncing correctly, while Ahmedabad has more than 5 million, so more inhabitants in Ahmedabad than in Croatia. But this is what makes everything, what makes life so beautiful, what makes it so interesting, getting us together in spite of all the differences, in spite of all these distances. So I do also hope that in the end, my today's lecture will be interesting for you and will be useful. The topic of my today's lecture is rule of law and constitutional review. What I basically try to do, I'll try to highlight the importance of the rule of law principle, to say something about the meaning of the principle, then to very briefly describe basic features of different constitutional or judicial review systems, especially ones that are or were and are adopted by the European countries. I'll try to also briefly explain why the countries of Central and Eastern Europe have opted for certain mode of constitutional review, and what were the reasons that lie behind that such constitutional choice. In the end, I'll just try to shed light on the case of the Republic of Croatia, on the role of its constitutional court in process of overall democratic consolidation of the country from 1990 onwards, and building the rule of law. So as it comes to rule of law, oh, sorry. Now it goes. Okay. So being itself an ancient idea, dating from Greek philosophers Plato and Aristotle, as so far as Western philosophy is concerned, the rule of law is surely one of the most complex, most debated, and at the same time, one of the most widely accepted concepts in modern legal thought. Moreover, towards the end of the 20th century, it has almost become a rule that nation states of East and West, as well as international, supranational organizations, express their support for the rule of law. Such support has become, let's say, usual since the end of the Cold War, so since 1990 onwards. Of course, on occasions it's only rhetorical. Political leaders at all levels champion the rule of law, be it they do so on all sorts of occasions, and to such an extent that in the end, the expression itself may become meaningless. But people themselves around the globe declare their adherence to the rule of law, their desire to live in a society that is governed by and under this principle. So thus could rightfully conclude that there is indeed a global support for the rule of law, and that it is generally regarded as a positive thing, as something that is in the end good to have on your side. Now, the international community has embraced the idea of the rule of law as a foundation of the legal order, together with international law. You see, the principle of the rule of law is embedded in the Charter of the United Nations, exactly in its preamble, and it is also explicitly mentioned in the preamble of the 1948 Universal Declaration of Human Rights. In Universal Declaration, it is stipulated exactly that, whereas it is essential, if man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. Now, both documents, UN Charter and Universal Declaration, are often considered to be essential parts of the constitution of the international community. So that's the universal level. The picture is similar at regional levels too, especially regarding Europe. Now, you might be familiar with the Council of Europe, which is an international organization created in 1949. It embraces now all countries of Europe. It is devoted to protection of human rights and to building capacities in the field of the rule of law overall. So following the UN documents that we have mentioned, the Council of Europe has adopted European Convention on Human Rights that was in 1950. That is today most influential human rights catalog in Europe, and in the same time most effective instrument for human rights protection in Europe. And that convention in its preamble also recognizes the rule of law together with political traditions, with ideals and freedom as a common heritage of European countries. Now, we can also say that at supranational level, the rule of law is also recognized as a constitutional principle. When I mention the supranational level, I mean the European Union, as the European Union itself is not a classic international organization, but is often, with good reason, characterized with as a supranational organization. So, in constitutional documents of the European Union, we will also find the rule of law. It started all in Maastricht Treaty. That was the treaty of the European Union adopted in 1992, in which basically multiple references to the rule of law can be found, though with largely symbolic meaning. But then it followed with the Treaty of Amsterdam, that was in 1997. It puts the rule of law together with liberty, democracy, and human rights among primary principles on which the European Union is founded. And finally, we have Lisbon Treaty of 2009, which is last in line of these constitutional documents of the European Union, where the term principle is now replaced with the term value. And in the end, it is stipulated that the European Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities. So these values are common to member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. And finally, we come to the national level. You see, the principle of the rule of law is today entrenched in many modern constitutions, though not all of them explicitly mention the term. But it undoubtedly forms part of the, let's say, ethical concept upon which modern constitutions are based. And as such, the rule of law has a pivotal role among basic principles upon which nation states rest. Now, although it surely goes for well-established democracies throughout the world, of course, it is my intention to highlight the special importance that constitutionalization of the rule of law has for newly formed states. And that was very evident in the case of the so-called new democracies of Europe. When we talk about new democracies, in Europe, we basically talk about ex-socialist countries. Namely, in the process of transition to democracy, which ex-socialist countries of Europe have been going through by the end of 1980s, beginning of 1990s, new constitution makers faced a challenging dilemma of complete change of till then existing political and social system. You see, the citizens of socialist countries have largely required disintegration of the old bureaucratic and authoritarian political system. They desired its transformation to pluralist democracy. So demands for change have been built around three prevailing ideas: democracy, human rights, and rule of law. The starting point in the process of acceptance of these, let's say, new values for each of those states. Sorry, I had to switch this slide earlier. Sorry. So the starting point in the acceptance of these new values for each of those states was basically the adoption of the constitution. Now, as we shall see, even a limited insight into the constitutions of Central and Eastern European countries illustrates clearly that new constitution makers overwhelmingly accepted the principle of the rule of law, or of the state based on the rule of law. In fact, large majority of these constitutions, including the Constitution of the Republic of Croatia, explicitly refer to the rule of law or to the principle of a state governed by law. I will illustrate that, but just before you can see this picture, upper right. So on the photo in upper right corner, you can see citizens of Berlin, today's capital of Germany, climbing over the Berlin Wall. So a physical barrier made of concrete that divided the city for almost 30 years. It was, of course, torn down in 1989, but not completely, as there are still traces of this wall throughout the city. If we are talking about the Berlin Wall today, then if you can take a look at this photo in lower right corner, the Berlin Wall today serves like a touristic attraction, of course, but also like an open art gallery. So it has very symbolic meaning. Now, on this slide, we have one political map of Europe. This one is interesting because it shows basically all countries that were created after 1989, 1990. Of course, in green color, you can see the countries that once were part of the Socialist Soviet Republic. Then in, what is this, violet, you can see all other ex-socialist countries that were part of socialist bloc. And if you take a look, there is a red arrow that is pointing out to my homeland. It's pointing out to Croatia. That's where the Socialist Federative Republic of Yugoslavia was. And in 1990, 6 or now even 7 states have emerged after the breakup of Yugoslavia, Croatia being one of them, together with Slovenia, Bosnia, Serbia, Montenegro, Macedonia, and last in the end, Kosovo. So why is this political map in front of us at this moment? Basically because the phrase rule of law as one of the fundamental values of constitutional order and one of governing principles of the state is explicitly mentioned today in each of constitutions of all former Yugoslav republics. It is also entrenched in most of the constitutions of ex-socialist countries, European new democracies. We could illustrate this very easily. For example, in 1995 Constitution of Bosnia and Herzegovina, Article 2 defines state as democratic state, which shall operate under the rule of law and with free and democratic elections. Republic of Bulgaria also stipulates that Bulgaria shall be a state governed by the rule of law. 2007 Constitution of Montenegro defines the state as a civil, democratic, ecological, and a state of social justice based on the rule of law. It's the same or very similar in the fundamental law, which is basically a constitution of Hungary, where the principle of the rule of law is mentioned already in its Article B1. It says Hungary shall be an independent democratic state under the rule of law. We could also take a look in constitutions of Romania, Slovenia, Slovak Republic. Everything, the picture, everywhere the picture is more or less similar. These states are usually defined as democratic sovereign states governed by the rule of law. So the rule of law is today firmly embedded into the foundations of democratic legal systems. Now, there are 2 points that I'd like to highlight here. First, to simply put the rule of law in constitutional text, well, that was of course easy. For new democracies, especially, the real challenge was to provide for its realization, and I'll try to illustrate that a little bit later. And the second remark, more general, despite universally acceptance of rule of law and despite its inclusion in constitutional documents, it might prove to be a difficult task to define the precise content of the rule of law. You see, in the words of an American professor, Ronald Kess, the meaning of the rule of law has been subject of innumerable scholarly discussions by great thinkers. But the rule of law still means very different things to different people. Well, that's an intriguing starting point for us. Why? Because we can ask ourselves, is it possible, as some argue, that this omnipresent concept is popular, that it is successful because it's vague, because it's far from clear? In other words, what does the rule of law actually mean? You're probably familiar with the phrase government of laws and not of men. That phrase is possible to trace from James Harrington's The Commonwealth of Oceania, published in mid-17th century, or from David Hume's essays published in mid-18th century. Of course, it was also famously accepted by one of the American founding fathers, John Adams, who then inserted it into the 1780 Bill of Rights, Constitution of Massachusetts. It was also later used by Chief Justice John Marshall in the landmark 1803 Marbury versus Madison decision, a decision that practically created the power of judicial review in the United States, as that power wasn't foreseen in the original text of the US Constitution. We can read upper right, the government of the United States has been emphatically termed a government of laws and not of men. That's citation of John Marshall. So many would agree that the famous phrase, though itself, of course, broad and as such inevitably open for further elaboration, captures the very essence of the idea of the rule of law. In other words, any exercise of the power should be subject to law. That's the idea. The man should be ruled by law, not by man. Or in words of a famous political thinker, John Locke, wherever law ends, tyranny begins. Now, a famous English jurist, Albert van Dicey, in his classical work, Introduction to the Study of the Law of the Constitution, published in 1885, formulated the concept of the rule of law that outlined its three main elements. And these elements are basically predominance of regular law as opposed to arbitrary power, then equality of law, and then third, importance of judge-made law, because judge-made law is, in that conception, best source for protection of individual rights. Of course, since Dicey, many attempts by numerous scholars have been made in order to elaborate the concept. Today, it is Today, it is widely accepted that there are at least two main views regarding the rule of law. One would be formal or procedural, and the other one would be substantive or material conception. While at the same time, many authors suggest their own conceptions which combine elements of those approaches. Now, formal conceptions are those concerned, let's say, with how the law is made and its essential attributes. It has to be clear, it has to be prospective. On the other hand, substantive conceptions are concerned, of course, with formal precepts, but also with some basic content of law, with questions of justice and morality above all. Of course, if one accepts that categorization, then it's possible to classify them further from thinner to thicker versions, etc., etc. And there are, you can see down right, there is a rule of law index. It says World of Justice Project. There are lots of let's say, attempts to measure the rule of law. One of them is inside that World Justice Project, which is basically a report that is trying to measure the rule of law based on experiences, based on perceptions of the general public, based on in-country legal practitioners and experts worldwide. So it presents basically a portrait of the rule of law in around 140 countries, and the scores and the rankings are also published. They are derived from household surveys, but also from expert surveys worldwide from legal practitioners. So it's just one of these attempts to even measure the rule of law. Now, one among many modern conceptions of the rule of law is that of Tom Bingham. Tom Bingham is an English jurist, former also a Lord Chief Justice. And Bingham, relying on John Locke's and Thomas Paine's ideas, first of all, suggests that the core principle is that all persons and authorities within the state, whether public or private, should be bound and entitled to the benefit of laws publicly and prospectively promulgated and publicly administered in the courts. And then Bingham further identifies 8 rules, or in other words, implications of the rule of law. We have them in front of us here. And let's check them together. So the first would be that the law must be accessible as so far as possible, intelligible, clear, and predictable. Then questions of legal right and liability should ordinarily be resolved by application of the law and not by the exercise of discretion. Third is that the laws of the land should apply equally to all, save to the extent, of course, that objective differences justify some differentiation. Then fourth is concern of protection of fundamental human rights. Law must afford adequate protection of human rights. Fifth is means must be provided for resolving without prohibitive cost, without inordinate delay, bona fide civil disputes, which the parties themselves cannot resolve. Then sixth is concerning ministers and public officers. At all levels, of course, they must exercise the power conferred on them reasonably, in good faith, for the purpose for which the powers were conferred, and without exceeding the limits of such powers. Seventh is that adjudicative procedures provided by the state should be fair. And the 8th point adds the, let's say, dimension of international rule of law. In other words, existing principle of the rule of law requires compliance by the state with its obligations in international law, the law which, whether deriving from treaty or international custom and practice, governs the conduct of nations. So, having all of that in mind, now we can go back to new democracies and constitutionalization of the rule of law. Why? Because it demonstrates the importance of constitutional or judicial review. In other words, it will demonstrate us the importance of courts in upholding the rule of law. We said already that incorporating the phrase rule of law was easy part. The real challenge was to provide for its realization. And those citizens strongly supported breakup with socialist ideology. Political legitimacy of these new democratic regimes heavily depended or considerably depended on creating confidence in public institutions. In other words, ensuring that all political actors obeyed the constitution, retaining their actions inside the constitutional limits. That was the crucial precondition for real success of new regimes in that transitional period. Of course, the limits of legitimate exercise of power had to be defined through interpretation of the Constitution. And that is why that is why an essential part in this process of constitutional transformation in upholding the rule of law had to be played by the judicial branch, or especially by those courts that have power of judicial or constitutional review. Performing their competences primarily through abstract and concrete judicial review, but also through protecting constitutionally guaranteed human rights and fundamental freedoms while deciding on constitutional complaints, constitutional courts can contribute considerably to the consolidation and realization of a democratic government. Moreover, some of those courts managed to contribute in making a new regime not merely a democracy, but also a Rechtsstaat. So, meaning a state governed by law and a state that is respectful of its citizens. You see, this term Rechtsstaat, this is a term from a German term in German language. It basically consists of two words. The first word is a German word for law, that is Recht, and the other word is German word for state, Staat, Rechtsstaat. In other words, that would be, let's say, the embodiment of a just state, not merely a state of legality. So, according to classical approach on the matter of constitutional adjudication, there are two main systems of judicial review. On one side, there is centralized or concentrated system, and the other one is decentralized or diffuse system. So this commonly used distinction basically depends on the answer on the following question: who is entitled with power to review the constitutionality of legislation? In decentralized system, all courts are engaged into the constitutional adjudication in particular cases or controversies. In other words, in decentralized system, all courts can resolve constitutional issues if such question appears before them in conventional litigation. So in that picture, judicial review is basically an ordinary activity of the courts, and it's conceived as a natural function of the judicial branch of government. So such decentralized model is usually known as the American one, as it was developed in the United States, of course, after the already mentioned famous Marbury versus Madison decision of 1803, and has further been accepted in many countries with common law systems. On the other hand, we have centralized system. If the power of judicial review is by constitution exclusively vested in the hands of just one institution, be it court or tribunal, it is in most cases called a constitutional court, and that institution is excluded from the judicial branch, then such system may be regarded as centralized system. Furthermore, such constitutional courts are usually empowered to examine statutes in abstract with erga omnes effects. In other words, it creates legal rights and obligations for all future cases. So erga omnes, as opposed to American decentralized system of judicial review, in which the effect of a decision declaring the statute to be unconstitutional is limited only to the case in question. So it doesn't have erga omnes effect. Of course, this, let's say, lack of erga omnes effect is supplemented here in American system with the principle of constitutional stare decisis, or with precedences that obligate lower courts to follow the Supreme Court's constitutional interpretation. Anyway, this centralized model is also very often described as the European system of constitutional review, although there are many variations concerning judicial review among countries of Europe. You see, namely through those centralized form of constitutional review is undoubtedly prevailing model in Europe. There are some European countries first that follow this decentralized model. These are some Northern European countries, Denmark, Finland, and Sweden. Then there are 2 European countries that have a mixed system, and that mixed system differs from each other. These are Greece and Ireland. And finally, there are 2 countries in Europe that do not have constitutional review of legislation due to the parliamentary sovereignty principle. Of course, you guess that one of them is the United Kingdom, while the other one is Netherlands. So, of course, if European system on one hand cannot be reduced to existence of specialized constitutional court, on the other hand, this decentralized system is not at all endemic to countries with common law systems. But still, I find this distinction to be useful, especially for the purpose of lectures like these, because all of the so-called new democracies, including the Republic of Croatia, have in the end accepted similar system of judicial review, the one that is usually conceived as the European centralized system. And that is why I will further try to shortly, of course, describe its main characteristics. And in the end, then I'll try to give an emphasis on the Republic of Croatia and the role of its constitutional court in process of democratic consolidation in building the rule of law. So when we are talking about the European model of constitutional review, that centralized European model was shaped according to influential normativist teaching, prominent above all in the work of the famous Austrian legal theorist. You can see him upper right, Hans Kelsen, and his model of constitutional court. This is one of his most famous works, The Pure Theory of Law. So according to Kelsen, only an organ distinct from the legislator and in the same time independent of it, as well as from executive, and that is constitutional court, should be empowered to annul unconstitutional acts. So constitutional court is thus acting like negative legislator, annulling the will of the real legislator, which is parliament. Now, Kelsen claims that in exercise of its function of negative legislator, constitutional court is substantially determined by the constitution. Its functioning, therefore, does not include any or almost any moment of free creation. Creativity exists, but it is reserved for parliaments. Okay, parliaments are positive legislators in this conception. Now, such specialized institutions have been introduced already in 1920, first in Austria and in Czechoslovakia. And during interwar period, similar bodies were adopted in 2 countries. One of them was Liechtenstein, and the other one was Spain. I think it was during Second Republic. Constitutional courts in Europe started, let's say, the real expansion of these institutions started after the Second World War. You see, after Second World War in 1945, Austria re-established its constitutional court, and then similar institutions were introduced all over Western Europe, beginning with Germany, Italy, then followed by France, Portugal, Spain also again, and Belgium. In the end, and we are talking 1980, all of the aforementioned countries have established their specialized constitutional courts. They all follow the European system of constitutional review, but of course, with some important differences among them. Consequently, besides choosing between, let's say, 2 dominant constitutional systems of judicial review, European and American on the other hand, constitution makers in new democracies in 1990 or from 1990 onwards also had to consider some specific elements characteristic primarily for French and German models. Let's just shortly see these differences. Now, French model was, or we should be precise and say, until recently was a system of exclusively a priori constitutional review of formal legislation. You see, duty to secure conformity of legislation with the constitution belongs in France to the specialized body, which is called Conseil Constitutionnel. And Conseil Constitutionnel preventively checks constitutionality of statutes a priori, meaning before they are promulgated. German model, on the other hand, is a mixed system of centralized control of constitutionality. It combines element of abstract and concrete review with special emphasis on a constitutional complaint. Now, constitutional complaint is an extraordinary remedy for protection of human rights guaranteed by the Constitution. You see, constitutional complaint is a procedure that enables review of measures of public authorities. So any person, basically, be it natural person or legal person, may submit a complaint of unconstitutionality if he deems that one of his fundamental rights guaranteed by the Constitution has been violated by the public authority. So it is an extraordinary remedy, and it is generally allowed only if all other remedies before national courts have already been exhausted. It also has to be lodged within a certain time. But constitutional complaint is definitely a great and hugely popular German addition to constitutional review, to constitutional adjudication. And you see, even the French partially adopted constitutional review in the end. It is not a constitutional complaint. Sorry, it's not a pure constitutional complaint. It's a sort of complaint that is allowed under certain conditions, but still they are changing their system. So, in spite of all above mentioned differences, all of these European constitutional courts perform the duty of the guardians of the Constitution. They resolve constitutional issues. They do not have a function to adjudicate conventional litigation. That always remains a function of ordinary judiciary. And as a consequence, constitutional court may stay outside or may remain outside the traditional division of power. And that's why they are usually seen as independent and autonomous powers. We could say a kind of fourth branch of government, due to its specific competencies, primarily through abstract and concrete judicial review, especially through protection of human rights when deciding on constitutional complaints. Constitutional courts contributed considerably to the consolidation and realization of democratic government. They have progressively evolved from this narrow Kelsen's conception of a negative legislator, vested with new strong powers. Constitutional courts have steadily assumed a role of positive legislators that, taking into account more active approach, strengthening their position, assist basically the legislative bodies in accomplishing their functions. So sometimes they even assume their role, but without substituting them regarding the legislation enactment. Now, over the years, some of these courts, in first line, that would be German Federal Constitutional Court, but also Italian Corte Costituzionale, they have become very influential, very powerful institutions capable of safeguarding the constitution and stability of democratic order, as well as of guaranteeing human rights. It was not surprising, therefore, that constitution makers of former socialist countries decided to follow the example of their West European predecessors. So the centralized European model of constitutional review, always, of course, with certain variations, was in the end adopted by European new democracies almost without exceptions, and with same expectations, if I may say so. So constitutional courts of these countries were supposed to strengthen the rule of law and to contribute in creating new relations between the state and its citizens. So that's something that goes basically for all of those constitutional courts, for all of those countries. If we would have more time in our hands, I would gladly share with you the history of constitutional review adjudication in the former Socialist Republic of Yugoslavia, as it was the only example of one socialist country, at least until 1985, when Poland introduced a similar institution. So Yugoslavia was the only socialist country that had the institutions of constitutional courts already starting from 1963, 1965. But of course, that constitutional review in socialist states differed very much, or differed completely than the existing constitutional review system now in Croatia. And as a final chapter, if I may, I think I have another 5 minutes. Is that?
Yes.
Yeah. Thank you very much. So I'll just try to conclude, and I try to say just few concluding remarks on my homeland, the Republic of Croatia, and on its constitutional court. You see, Croatia adopted the constitution in 1990, and with the adoption of the new constitution, the Republic of Croatia was basically set on new constitutional values that differed completely from principles exercised in the old regime. And a special emphasis was given exactly to the rule of law and protection of human rights, and consequently, of course, to the Constitutional Court as the institution endowed with the task to uphold fundamental values of the constitutional order and to create relations between the state and individuals by exercising its constitutional authority. However, unlike some constitutional courts of new democracies that gained reputation of activist institutions already in the initial period of their operation, Croatian Constitutional Court at the very beginning accepted, let's say, passive, almost subordinated role compared to legislative, notably compared to executive branch. It was heavily influenced by the political question doctrine. Of course, one must have in mind that first few years of post-socialist constitutionalism in Croatia, or the whole first stage of constitutional development from 1990 to 2000, was heavily influenced by war that lasted from 1991 to 1995. And during that period, the Constitutional Code was rather restrained, was mainly focused on defending these fundamental constitutional principles, just occasionally showing some inclination towards more activist approach. But entering into force, European Convention on Human Rights that we have mentioned at the beginning of this lecture, and that happened in 1998 for Croatia, and of course followed by some amendments of the normative framework, including reforms on constitutional complaint, that were signs that state of affairs is soon to change. And after elections, presidential elections in 2000, after significant constitutional reforms of 2000 and 2001 that reformed the parliamentary system of government or semi-presidential to a parliamentary system of government. It also introduced and strengthened constitutional court's competencies, and then the court at that time started to strengthen democratic process as a whole. It it abandoned its formalist standpoint predominantly. It opened doors to a more liberal approach, and it started in whole to significantly expand fundamental constitutional principles, notably the principle of the rule of law. And of course, in the same time, the Constitutional Court opened the doors, engaged in judicial dialogue with other courts by referring to decisions to the jurisprudence of famous European courts, such as European Court of Human Rights of the Council of Europe, or taking into account the jurisprudence of other national courts, German Federal Court in first place. And of course, one important thing, through Constitutional Court's case law, the European Convention on Human Rights gained a sort of special status in Croatian legal order. And namely, even the Constitutional Court even repealed certain statutory provisions, reviewing the conformity of a domestic law directly with the Convention, not with the Constitution, but directly with the Convention of Human Rights. And of course, in 2013, the Republic of Croatia, we have to take account the EU law, because the Republic of Croatia is still the last country that acceded to the European Union. That required again a amendment of the Constitution that happened in 2010. And finally, one might conclude that the accession of the Croatia marked the symbolic end of this transitional period. It did, but years that followed, it's almost 10 years now, show that full democratic consolidation is still ahead. But assessment of the Constitutional Court's performance through the transitional period shows that it was definitely a positive and a constructive factor of constitutional democracy, that it gradually developing its capacity, occasionally displaying some sort of activism in its decisions. The Constitutional Court in the end has shaped the constitutional landscape significantly, and eventually it managed to establish itself as the real guardian of the Croatian constitution. Okay. I'll end here. Thank you very much. I'm sorry if I missed the time.
No, sir. No, sir. Thank you so much.
Thank you,
sir. So thank you for painting this entire terrain of rule of law for us along both its principles and its critical and application-based measures. So your talk has evoked certain questions, and I would like to share them with you. So one of the faculties at our institute, Dr. Vikas Upadhyay, he also teaches constitutional law. He asks that how can the rule of law be in practice where social norms are not as per rule of law? So we have rule of law on one hand, and then we have social norms challenging the rule of law that are there. And his second question is, how can discretion be accommodated in rule of law?
Okay, these are great questions. I will just show you for the end. This has nothing to do. This is my city. I prepared some photos, so just that you can see them. Of course. So these are both great and important questions. As I try to illustrate, I don't know if I managed to do it. Hopefully I did. On one hand, there is this formal conception of the rule of law. For European new democracies, it was of huge importance to entrench the rule of law into the constitution. Then it was up to constitutional courts to reflect on its real content. I could also give some examples of constitutional courts rulings on what the rule of law is, what does it require from state bodies. I also try to highlight that there is another aspect of the rule of law. That's exactly what professor is referring to, there is this, I don't know if that's the right term, dichotomy, or there is this difference. There is a gap. There is a gap that has to be bridged. In my view, of course, I'm not, it might sound like that, but I'm not idealizing constitutional court. I'm not idealizing judicial activism at all. It can be a powerful tool, but of course it has its limits. But it can significantly shape the constitutional landscape. It also, from the experience of Croatia, but also from other European countries, ex-socialist democracies, it can also, in some sort, awaken that feeling among citizens, because that was one of the main challenges to change the mentality. That's what constitutional courts, through its decisions and basic or interpreting the rule of law, can do. I'm not sure if I answered your question. I'm sorry, but I just try to highlight. Yes, of course, you are absolutely right. So what I tried to illustrate with these yeah, let's see. This is one of many prerequisites, one of many conceptions of the rule of law. We could have changed. We could have choose any other, but I've chosen it because, in my view, it is clear enough. It shows all the main points.
So we have another question. Neeraj Kumar Gupta, sir, he is also faculty over here. He teaches environment and criminal law. He asks that the rule of law understanding without equitable distribution of resources appears to be incomplete. Do we have some provisions in European countries which connect distribution of material resources with rule of law?
Could you repeat the last one? Do we have?
Yes, sir. He asks, do we have some provisions in European countries which connect distribution of material resources with rule of law?
Yeah, of course. Okay, I understand the question, and I couldn't answer precisely on that question. Distribution of the rule of law, equal distribution of the rule of law, and all its prerequisites is not, of course, easy to achieve. One tool is through protection of human rights and fundamental freedoms. As it comes to European countries, I guess you are aware that through Council of Europe and European Convention of Human Rights, this a revolutionary mechanism for protection of human rights and fundamental freedoms was created already in 1950. So all European countries now, without exception, I think only exception would be Belarus, are now parts of, or members of the Council of Europe. So we could say in that sense that the European Convention of Human Rights is a sort of supplementary international constitution for all the European countries, and that the European Court of Human Rights acts in a way as a federal constitutional court in Europe. So through these documents, through these instruments, let's say similar standards of human rights protection as a part of the rule of law principle can be distributed all over Europe. But of course, it always depends on each country and its conditions. Because despite all of these international mechanisms, especially European Court of Human Rights and its convention, it's always the primarily responsibility always lies in the hands or in the institutions of nation states.
Thank you, sir. So we have just one more question. It was mentioned that in Eastern European constitutions, they often mention or entrench rule of law. So the question is, how do they entrench rule of law? Do they create these eternity clauses or something like we have in India, basic structure doctrine, or how do they entrench the rule of law in their constitutions?
Okay, basically these articles of the Constitution that entrench the rule of law are more or less all very similar. That's what I try to highlight. And it was easy. It was sort of you must do that. But the idea of realizing that principle is something else. So how? Exactly through constitutional court interpretation. Exactly through constitutional court interpretations. So all these articles of the Constitution, I'm missing the word, sorry, are very similar. But that's the basic idea. To realize it through constitutional interpretation or through the work of the judicial branch in general.
Thank you, sir. So we have one question from our director. She asks that how does international protection of human rights law impact rule of law? So you have talked about Croatia. So in general, does the international protection granted to human rights law also impact the idea of rule of law as well?
I would say that it hugely impacts the rule of law in general. Starting from 1945, starting from UN Charter, starting then from Universal Declaration of Human Rights, that was the beginning of establishing of common standards in protection of human rights throughout the world. Yes, in Europe, we had the first real concrete answer. That was the European Convention on Human Rights.
So, thank you so much, sir, for your lecture and for answering all our questions. We have our director, Dr. Madhuri Parekh, with us. Ma'am, would you like to say a few words?
No, thank you so much for the session. I just missed the initial part of the session because of some my preoccupation. But thank you so much for being with us. Thank you.
Thank you, sir. Yes.
I'm sorry. I'm very grateful once again for inviting me. I do hope that I answered your questions. I am sorry if I got lost in translation for some parts.
I just would like to read your articles. So if you can send me a copy.
Absolutely. Thank you very much. I will do that. It will be an honor. Thank you.
Thank you so much, sir. It was great hosting you. It was great listening to you. Thank you.
Thank you so much. Thank you.
Thank you, Professor Bačić.
Thank you, Professor Ivastava. Thank you all for inviting me.
Thank you.
Thank you. Have a good day.